human rights can be protected within national borders or internationally. In this class, we will explore the mechanisms for human rights protection that function at a domestic or national level. Under a dictatorial regime, the human rights protection mechanisms that we will mention do not function independently. If they function at all, it is purely cosmetically. In such situations, human rights defenders will resort mostly to international denunciation and solidarity. At the national level, they will avail themselves of whatever alternative means is suggested by their imagination and courage. Ever since the British Magna Carta of 1215, judges have been considered the guardians of basic rights whenever a person has been detained by public force. Indeed, under the Magna Carta, a detainee had to be taken immediately before a judge in order for him to assess the legality of the detention. This judicial recourse is universally known as habeas corpus, from the Latin to present the body of the detainee. But there are also judicial actions bestowed to individuals under domestic law to enforce human rights other than personal liberty. Thus, in many Latin American countries, for instance, there is a special class of claims that may be submitted before high courts in case of other alleged human rights violation. In the United States, there is a special law enacted in 1789 named Alien Tort Claims Act, also known as Alien Tort Statute. Under this law, any foreign person within the United States can submit a claim for damages against another person for human rights violations committed outside the US soil. Since the Filartiga versus Peña Irala case in 1980, which concerned a human rights violation that had taken place in Paraguay, this law has been used in the United States legal system to address human rights violations committed abroad by and against non-US citizens. Compensations have been awarded by the courts of the United States. However, they could not be effectively collected for the lack of US-based assets belonging to the defendant. Finally, there is another legal notion that has been used to address domestically human rights violations committed outside the state boundaries. It is the so-called extraterritorial jurisdiction, under which a state can prosecute certain crimes against international law, including some human rights violations, even if they were not committed in its territory. The grounds for such extraterritorial jurisdiction include the facts that the victim or the alleged perpetrator are nationals of the state in question. In 1993, the United Nations General Assembly approved the Paris Principles on National Human Rights Institutions. These principles set forth the responsibility of national human rights institutions to promote human rights, to draft reports on the subject, to encourage ratification of international treaties on human rights, and to fight all forms of discrimination, among others. The United Nations principles also established that national human rights institutions should be pluralistic and independent from public authority. Now, there are two different kinds of national human rights institutions, depending on the scale of the violation they address. As will be seen in the class dedicated to the concept of transitional justice, whenever there have been massive human rights violations, societies have the political, legal, and moral need to investigate such atrocities once the crisis has been overcome. Thus, several truth commissions have been created throughout the world, most notably in Argentina, 1983, Chile 1990, and South Africa 1995. On the other hand, in times of sustainable or normal functioning of a given society, human rights violations can still take place. To address these situations, some countries have created, in addition to the judiciary, the Office of the Ombudsman or the Defender of the People, an institution first established in Sweden 2 centuries ago. It consists of an autonomous public organ in charge of receiving denunciations from citizens regarding human rights violations and of submitting claims before the courts of law to stop them. It does not have enforcing powers. It rather acts by publicity, persuasion, and shaming. Regarding crimes, domestic legislations delegate the power to prosecute criminal conducts, including those that can amount to human rights violations, to a specialized organ. This organ can be part of the administration, such as an attorney general in common law systems, like the ones of the United States and the United Kingdom. It can also be an autonomous organ, such as a national prosecutor, as it is the case in the continental law tradition. As was seen in the previous class on the human rights movement, after the Second World War, governments led the political and moral momentum that gave birth to the international system for the protection of human rights. However, with the tensions of the Cold War on the rise, such momentum greatly subsided in the 1950s. In the 1960s, non-governmental organizations, known as NGOs, took the lead in the promotion and defense of human rights throughout the world. The work of NGOs is all the more important when the human rights violator is the state itself, especially during exceptional periods such as dictatorships, when all the state functions are concentrated in the de facto ruler or single person. One of the most famous examples of a national human rights NGO is the Vicaría de la Solidaridad, the Vicariate of Solidarity, supported by the Chilean Catholic Church. It gave assistance to thousands of persecuted people during the years of the military dictatorship led by Augusto Pinochet. In many other countries, national human rights NGOs have grown since the 1970s, to the point that there is hardly a nation that does not count with at least one. As we stated in the previous class, the development of the non-governmental human rights movement was the driving force that led to a growing human rights awareness worldwide. Finally, it gave rise to the development or strengthening of human rights institutions at the United Nations and also at regional systems of human rights protection in Europe, the Americas, and Africa. This driving force also contributed to the creation of human rights institutions as well as to the adoption of human rights policies in many countries. In the last 2 or 3 decades, many national NGOs have legally represented before regional human rights protection mechanisms people who alleged the violation of their basic rights. To that effect, they must first exhaust the domestic remedies available. This has prompted national NGOs to litigate first before the courts of their own country, thus trying to comply with the requisite of having exhausted national legal remedies. Private lawyers and legal firms have also developed an increasing activity in recent years, representing purported victims of human rights violations before the national courts and ultimately before the regional protection mechanisms. Please visit our website, mucchile.com, and watch the next class of this course.